Good afternoon and good morning, everyone, and welcome to Thrive, a monthly webinar series brought to you by ArcPoint Labs, your single source employer solutions provider, helping business leaders create compliant, safe, and healthy workplaces that thrive. Today's topic, reducing legal risk in the workplace, building and implementing an employee handbook that actually works. My name is Ryan West, your host and Thrive specialist, and pleased to share the virtual floor today with attorney Jenna Shives. Before Jenna takes the virtual stage, however, a few brief and important announcements. First, ArcPoint's Thrive webinars, unless otherwise announced, are held the third Thursday of every month from 1 o'clock to 2 o'clock p.m. Eastern Time, 10 to 11 Pacific. They're free to attend, they're accredited for HR professionals, and they offer timely, practical information and guidance on a variety of topics, all anchored in ArcPoint's suite of employer solutions. Today's topic is grounded primarily in ArcPoint's drug and alcohol policy development solution. Secondarily, our DOT compliance, background screening, and drug testing solutions. Next month, we're excited to feature guest speaker Dr. Melissa Snyder Adler, a board-certified addiction medicine physician and medical review officer who's going to kick off Q3 with the very timely webinar, Medical Cannabis, CBD, and Safety-Sensitive Work, Why This Is Not Like Other Medications. Now, if you're like so many people and have questions about CBD, medical marijuana, hemp, the difference between them, you do not want to miss July's webinar. Registration for July's webinar is now live, and you can register right now by clicking on the link that will soon be posted in the chat. Second, once today's webinar concludes, there will be a survey asking for your feedback. Process is super quick, it's easy, and it gives your voice an anonymous platform to influence the type of Thrive content that will best serve you and your business. Today, we have an expert attorney presenting because you, the ArcPoint Network, asked for a webinar on handbook development and implementation. We have an expert physician speaking next month because many of you asked for a webinar on medical marijuana, medical cannabis, and CBD. Okay, so keep the feedback rolling in, and we'll continue to do our best to deliver the topics and the speakers that you request. And lastly, I want to quickly address the frequently asked questions that we get at the beginning and end of our webinars. To save time, we just posted the FAQs in the chat, but I do want to emphasize an important point about certificates of attendance. If you're here to acquire some helpful takeaways, hop on, hop off, maybe get a question or two answered by our expert today. Excellent. Welcome. We're happy to have you always. But if you'd like a certificate of attendance emailed to you, you have to make sure you're not only registered and logged into Thrive webinars under your name, but you also have to attend the entirety of each webinar from start to finish. Okay? Any questions, let me know. Please go to the chat to review those other FAQs and also say hello. Let Jenna and myself know where you're logging in from. If you have questions for our presenter, please use the Q&A function and use the chat for everything else. If you want to engage with each other, share some comments, some stories, some relevant information, please use the chat. If you have a specific question that you'd like Jenna to answer, please use the Q&A. I know there's going to be a lot of questions. We have an attorney today, and we don't want to miss those questions. So use the Q&A. It is now my pleasure to introduce today's presenter, who is closing our Q2 Reducing Legal Risk in the Workplace three-part series, an experienced and respected labor and employment attorney with Krieg DeVault, Jenna Shives. Jenna brings a broad litigation background that includes employment disputes, commercial and environmental matters, and appellate work, and has spent a significant portion of her career helping employers stay ahead of the compliance curve, or the curve on compliance. From navigating government investigations to advising on data privacy, AI, she offers the kind of practical, grounded counsel that HR professionals can actually use and use with confidence. Thrilled to have her with us today. Jenna, welcome to Thrive. Thank you for being here. The floor is yours.
Thank you for that introduction, Ryan, and good afternoon and good morning to everyone. It seems like we have really good representation from across the country. I've seen California, North Carolina, Pennsylvania, Colorado, Florida, Ohio, Las Vegas. So we have a good group here today. As I go through my presentation, remember I am an attorney, but I am not your attorney. So if you need specific legal advice as we go through here, I'll try to keep it general. I'll try to make sure your questions get answered in the best way. But if there are specific questions, depending on the nature, we'll have to talk about that offline and follow up. But let's get into it today about talking about how to make an employee handbook that actually works. So our goals for today are to review employee handbooks and policies with alignment for actual organizational practices, how to analyze your policies for consistent application and associated risk, and apply documentation best practices to support effective employee and HR functions. Just how we want to spend our day, right? Talking about employee handbooks. But this hour that we spend right now will be really helpful to go through to mitigate problems that you might have later. I do see a question, and here are the slides available. They will be available after the chat. And I'm happy to ask questions, as Ryan mentioned, through that Q&A function as we go along if anyone needs it. Okay. So first, why should we even have an employee handbook? They're not legally required. They're not documents you have to have for your business. But what are the benefits of it? First, it communicates and establishes company policies. It establishes practices and procedures. It provides employees with guidance and protects the company from lawsuits. So you might think, well, doesn't the company just make the rules no matter what? Isn't it their prerogative? Yes, it is. But having a handbook that explicitly says that the company has discretion to perform these acts helps protect it in a lawsuit. For instance, saying that the company may terminate an employee for certain conduct allows it to have wiggle room and discretion. Saying that the company has the right to implement a performance plan means that it may, but it doesn't have to in every circumstance. Or words such as, these are only guidelines, set the company's authority. The handbook explains expectations so your rules and workplace runs as smoothly as possible. It also helps document institutional knowledge. So there might be that one person within your company who has everything stored inside their brain. Great. You know that you can go 5 doors down in the building and talk to somebody else and they are going to have the answer. What happens when that person is sick? What happens when they're on vacation? What happens when they choose to retire? All of that company knowledge walks out the door. Having a handbook institutionalizes that information in a way that isn't solely reliant on 1 or 2 people who have been around forever. And one of the biggest issues that I see in my realm is a one-size-fits-all handbook that doesn't actually reflect how your company operates. It's kind of the difference between buying clothes off the rack versus buying clothes that are tailored for you. One is going to fit perfectly and be exactly how you want it to look and make you feel your best and feel most confident. Others might fit just a little bit different. It's probably right, but might be good enough, but isn't really accurate. But I've seen handbooks that say we provide paid PTO because that's the template that they got from a third-party vendor. Well, this company doesn't actually provide PTO, never has provided PTO, and all of a sudden there's an employee who is at the end of their employment and says, well, I should be paid all of this PTO time, and has never actually gotten it. That can create a huge risk for the employer. Having a handbook that actually reflects how you work, make sure that the company is protected in EEOC investigations, Department of Labor investigations, state agency investigations. It prevents employees' complaints and uncertainty. It helps defeat or mitigate allegations of unequal treatment, even if it's entirely unintentional, and it saves headaches, time, and money. One practical way that we see handbooks come into play is at an EEOC complaint process. So if you are familiar with the EEOC process, the agency will ask employers to submit what's called a position statement and say, we understand an employee or former employee has made allegations against us. The allegations are not true. Our company doesn't discriminate. Here is an excerpt from our handbook that shows we do not discriminate. So having that information up front that we can point to, that we said, no, we have a policy on this, that is immediate documentary proof that can help support and refute claims of discrimination and mitigate risk down the road. So I want you to think about, when was the last time that you personally read your employee handbook cover to cover? Was it in the last month? Was it in the last year? Was it 7 years ago when you joined the company that you're with now? And you were given that sign of paper that says, the slip that says, please sign and acknowledge that you received that. So when you read through it, were there any surprises? Did you notice that anything that needs correct or changed? I see some comments that someone revamped their entire last year. It hadn't been updated since 2018. As we all know, the world has dramatically changed since 2018, especially with the explosion of remote work and some of the other laws that have come into place. So as you go through here, the last changes and the last times, you want to make sure that you're really making sure that that reflects how you do work, because it might have been accurate in 2018 when you did your company update, but that might not be the company you are today. It might have had significant growth, growing from 30 employees to 100 employees, which then triggered different laws and different protections. So as you go through the handbook, it's always important to think about, is this how our company actually operates? Set aside the legal question of, is this the law? Because that doesn't have to be your burden to know all those things. Just, is this what your company actually does and what your company actually believes in? So as we talk about developing a handbook, there isn't a right or wrong answer about what should be included or not included in a handbook. But if you're going to have a handbook, there are policies that should be included just to help mitigate risk. And again, this is entirely dependent on your organization. It will depend on how many employees you have, where they work, what type of industry that they're in. Are they in a highly regulated industry or not? But let's talk about what you should always expect to see in one of these handbooks. First, an introduction and purpose statement. This tells the employee that these are the policies of the company, why. It also states that the company intends to comply with the law and our general expectations of employment. It also generally should explicitly state that it is not a contract. And when I talk about my point of reference for experience, I am in Indianapolis. I am licensed in Indiana. So as a general sense, what apply in most states of what I'm saying. But for instance, in Indiana, when we have that language saying not a contract, then no employee can come and say, well, employer, it doesn't matter that I violated these 3 other employees because you haven't been following policies 1 through 10 and you breached first. That's not what we want. And that's not what a handbook should be. It is not a contract, because you don't want your employee holding you to every single letter of what might be a 50-page document that is a living document. So you don't want someone to claim that they could have a claim against you for not following it. It should also state that it's an all-inclusive, it should not state it's an all-inclusive document, but rather a guiding document that's subject to change at any time and really just sets a tone for your workplace culture. There should also be an acknowledgement form in every handbook. This shows the court or the EEOC or anyone else who might ask that, yes, your employees are given the ground rules and they know what they are. They're expected to know what they are. They're expected to follow the policies and procedures. And it helps the employees know that rules are applied uniformly across the board and apply to everyone equally, from the CEO down to the newest hire in the most junior role. As we go through, there should also be an at-will employment statement. Every state except Montana is generally an at-will employment state. So there should be a statement in there that says the employment can be terminated at any time by either party without cause. It should be clearly stated, and it should include a disclaimer that nothing in the handbook alters that at-will status. And so you want to avoid language that implies or guarantees employment based on the words of the contract, based on the words of the handbook. You should also always have an equal opportunity employment and anti-discrimination statements, which verify that the company will not discriminate against any protected classes under Title VII, the Americans with Disabilities Act, the Age Discrimination in Employment Act, GINA, which is the Genetic Information Non-Discrimination Act of 2018, or any state or local laws. And just a brief acknowledgement about GINA, in case you're unfamiliar with that. That protects individuals from discrimination based on their genetic information. It applies to employers with more than 15 employees, and you cannot use genetic information to make decisions regarding hiring, firing, promotion, job compensation, or job assignments. So including all of that information here shows up front if you're ever questioned that is the policy and is the way that your company operates. There should also be a reporting procedure for methods for allegations of discrimination, and there should be multiple channels for reporting, whether that's directly through HR or if you have someone in the HR chain of command who you're complaining about, there should be a separate mechanism, and the employee should be informed of how to do that. There should also be anti-harassment language that has a sexual harassment policy, again, providing multiple avenues of reporting. And you should also think about if you have local ordinances or state laws that apply in addition to the federal. It's often good to also have policies for workplace violence and bullying, and have clear cross-references to other policies where it matters and where it makes sense. It's also important to have information in your handbook about leave types, whether there's federal or state military leave, FMLA leave, ADA reasonable accommodation leave, jury duty leave. In Indiana, we recently have a school leave that allows parents to have a dedicated amount of time that will be spent on school activities for their children, for parents or guardians. And then it's also important to have information spelled out about vacation time or paid time off, because as all of you probably know, a lot of this information that is in your handbook will explicitly be how PTO vacation time is paid out at the end of an employment. For instance, in Indiana, the default is that vacation time is paid out unless you have a policy stating the opposite. So it's fine to not pay out vacation leave at the end of the day, but you must have a policy stating that. Your local state probably has rules that are the same that explicitly dictate when vacation or PTO need to be paid out. So just make sure that you're aware of that and fully paying attention as you go through your handbook, that it complies not only with where your company operates physical locations, but where your remote employees might be as well. Because as long as you have one employee in a state working remotely, it is very likely that laws of that state will apply to the employee, even if it doesn't apply to anyone else. So other provisions to consider are remote work policies, attendance policies, workplace conduct and expectations, social media policies, policies about company phones, computers, and internet use and privacy. And I expect that you will hear a lot in the next several years, if not months, about internet use and monitoring of company equipment, especially as employees work remotely. There are more hybrid schedules. What an employer can do to track productivity, have those devices installed on company equipment. There are going to be a lot of legislation and laws monitoring this throughout. So that's definitely something to keep an eye on. Other provisions you should consider: substance abuse policies, compensation types, expense reimbursement, which I see is my typo on there, bonus provisions, benefits, how AI is used in employment decisions. This is as a result of a 2026 law from Illinois, and that law that explicitly prohibits using AI for employment decisions that can have impact on individuals without several verifications behind it. So we can talk about that a little bit more in detail. But it's always important to make sure you're thinking about these policies as you use them in connection with your business. I have a friend who's a recruiter in Illinois for a large multinational corporation, and he was telling me about all of the AI tools they're implementing. And I said, "Oh, how did you get trained on this new law?" And he said, "What law are you talking about?" And I said, "Well, there's this law in Illinois that says you can't use AI except in limited circumstances. It must be disclosed to the applicant. There are conditions of how you do it to ensure that there isn't any discrimination going on in the employment decision, whether intentional or unintentional, just through the use of AI." And he had no idea. So a lot of this information evolves and change over time. That's again one that it didn't matter in Illinois last year for a handbook, but now it does. So you need to keep aware of circumstances and changes to make sure your handbook stays current and how you're actually working in the company. Other policies that could be helpful to consider are EAPs and wellness programs, fraternization policies, use of company vehicles, if there are tuition reimbursement, if you have specific policies and procedures for nursing mothers and what the protections are for those, it can be helpful to have in your handbook. So let's keep going through then. So talking specifically, I talked about that AI in Illinois. The AI law in Illinois prohibits the use of AI or strictly regulates the use of AI in any terms, privileges, or conditions of employment, their tenure, discharge, and discipline, hiring, promotion, recruitment, renewal of employment. And I think Illinois was a leader in this, but you're going to see a lot more states come in and say this could be an impact of how things will need to go. So let's see, we've got a couple questions in the Q&A. Let's see here. We've completed our employee handbook and we have had it reviewed by a third-party HR consultant. Are you willing to review it at no cost as a legal reference point as well? I see that question on there. My contact information will be there at the end. As an attorney, I have conflicts and issues that I need to work through our company. So if you go through, just contact me. I'll follow up with you about that. Also, I want to make sure that you're in a jurisdiction where an attorney in our firm is licensed to practice. So we're making sure to give you the best up-to-date information. Let's see here. Oh, I see Tom. Hi, Tom. Could you please address workplace conduct in relation to the NLRB and provisions calling for being respectful in the workplace? Yes. So let's talk about that. When you have generic or broad terms about being respectful in the workplace, my thought on how to approach provisions like that use somewhat soft or discretionary language is to think about it from a reasonable person standard. And so if you as the HR administrator, HR executive are going to be called to apply this policy, what does it mean? Do you know what it means to be respectful in the workplace? Do you have the same idea of what it means to be respectful versus the person sitting next door to you? Do you have the same idea of what it means to be respectful as your CEO? Do you have the same idea of what it means to be respectful as a delivery driver might? So you really need to think about, as you tailor these policies, what you're asking of your employees and how it could be applied, because you don't want to run into a situation where one person is considered respectful and another person is not. An example of respectful and disrespectful language could be, for instance, calling someone sweetie in the office. If it's the 75-year-old woman receptionist who has been with the company since the day it founded 50 years ago, and she walks in and tells everyone, "Good morning, sweetie. Nice to see you. Good to see you. Happy to see you, sweetie. Oh, thank you for dropping that off." Are you going to treat her the same as you treat a 45-year-old man who's commenting to one particular 20-year-old intern? "Hey, sweetie, how you doing today?" "Oh, that's a pretty sweater you have on, sweetie." It's the exact same word, but how are you going to apply it? And are you going to say that in one instance the word was respectful and in another instance it wasn't? So as you go through your policies, think about how you would actually apply it and what you would do. Let's see here. There's another question about, as benefit options may change annually by broker, should they be included in depth in the handbook without subjecting yourself to annual changes? I think it's always beneficial to have benefits information separately in its own policy, its own leaflets, distributions that you can give out. And in your handbook, you can have language that essentially says, this is information that will be provided from your benefits specialist. This will be provided by this person. This will be provided by this person. So you don't have to update your handbook every single time a benefit might change. Also, because benefits can vary widely depending on who enrolled and what option they chose. So I think that's a good place. You can have a catch-all that refers them to an external document because you can't expect it to be updated annually. And that information will always change as appropriate. And then you don't also have to be the one summarizing it from your broker. You're keeping it consistent with their language. Okay, so I'm going to move on from here. So, how do you build policies and handbooks that actually work for your company and hold up to scrutiny? Easiest way, have it reviewed. I do mean have it reviewed by an attorney when I say that, just to ensure compliance with laws. But what does that really mean? It doesn't alleviate authority from you as the HR specialist either. Review the handbook, find inconsistencies with how your company operates versus what is written, and ask for a legal review. As I get a handbook as an attorney, I can read through it and I can say, yes, policy A complies with the law. Yes, policy B complies with the law. Policy C, there was an update. Let's update this. Policy D, good. Policy E, good. But that doesn't mean it actually applies to your company. If you have a company of 10 employees, a lot of the larger discrimination laws that we talk about aren't going to kick in until 15 plus employees. Do you need that language in there? So you really need to think about how you would talk about your company and what that looks like. A 10-person company is going to operate and have a different chain of command versus a 100-person company versus a 1,000-person company versus a multinational corporation. So you really want to make sure in the review you're doing it in tandem with an attorney or someone else internally who's been charged with this task to fit your circumstances. And that is going to be the biggest way that you mitigate risk, is finding policies that actually reflect how you operate. I had an instance with a client who was questioned by an employee about whether or not she offered a certain benefit. She had never offered that benefit ever. She had 6 employees and it was simply not something she offered. She was given a handbook by a consultant that she just used and said there was this benefit. And all of a sudden she had to scramble and do essentially damage control to make sure those people had that benefit. It cost her more time and money, something she was not required to provide at all. But because her handbook said it, then it was written in a way that she didn't have a choice and had to essentially spend time and money and headache fixing a mistake that if she had read the handbook at the time she got it, she would have realized that's not how her company actually operated. So, what can you do also to mitigate risk? Follow company policies, follow company policies, follow company policies. It's not a typo that I have it on there 3 times. It is that important because that is going to show consistency in the application of your rules and how you actually work, to show that if anyone is ever questioned, you weren't singling someone out based on a protected characteristic or based on who they were. It was simply that you were following company policies. If there's any doubt about the policy, or if you need to deviate for it from some reason, document why that deviation was done. But if you notice a pattern that every single time a policy comes up that you have to deviate and your deviation becomes the norm, then change your policy. It's that simple. You can make sure it actually works and meets you where you are now. I've likened it before to that pair of pants that you might have had in the back of your closet for 15 years, that if you're going to lose weight and one day you'll fit in them, your handbook isn't like that. Your handbook shouldn't be just sitting waiting for you to fit into it again. Your handbook should fit you where you are now. So if you notice a pattern that something just really isn't working, change it. And make sure you train everyone on important policies too. As a real world example from this, I had another client who had a 1-year renewal cycle in all of its contracts for all of its employees. And as part of that, they chose not to renew an individual who had gone out on military leave that year. The individual complained, said that they believed it was discrimination based on their military leave usage, and that they were treated unfairly because of that. So the US Vets Agency investigated, looked through, and as part of that, they asked for documentation relating to any other employee of the company who had taken military leave in the last 5 years. And because our client had a written policy and they had clear documentation of every other time someone used military leave, and we could show where that other individuals' contracts were renewed throughout, that documentation and that training on policies helped show that the choice not to renew this individual's contract had nothing to do with the military leave at all. And we had followed our policies in the examples with the other individuals. And it really helped reinforce to the investigator that we were following everything correctly. And without that other documentation, without those other evidence of what they considered to be the correct application of policies, it might not have been that strong for my client in this instance. So having those documented instances of following your policies and deviating from the policies will help you if risks arise. And to be clear, I am not saying that having a policy will prevent any risk. As we probably all know, anyone can file a claim at any time for any reason, but how quickly you shut down that claim can be supported by your handbook and by your documentation. One thing that a lot of people will hear, as if you haven't already, is why don't we just use AI to generate a handbook for us? You can do that. And to be clear, I am not anti-AI at all in this conversation. I'm a certified informational privacy professional. I use a lot of technology in my practice. I advise clients a lot on technology in my practice. But if we're talking about AI, I want to give you real world examples of the policies in the handbooks, and we can talk about how this has been consistent with what we've talked about so far or inconsistent with what we've talked about. So just a quick recap, generative AI is the AI that will create a handbook for you from scratch. But remember, the final product can only be as good as the information you supply it. Junk in means junk out. Highly tailored in means highly tailored out. The other use you can be for editing functions. It can take your existing handbook and compare it to the laws as you may request. So I'm going to give you an example, and I used Microsoft Copilot to generate everything we're going to be talking about next. So I told Copilot, I need a company handbook. And the screenshot you see is the entirety of the company handbook it gave me. So this, I haven't edited anything out of this. It has a company overview, employee basics. It does say it's at will unless otherwise specified. And it says it's an equal opportunity employer and prohibits discrimination and harassment. Great. Then it says work hours and attendance. Work hours are typically Monday through Friday, 9 to 5. I didn't tell it that. It just gave the standard information that it thinks would be in a company function. It has compensation benefits. It has paid time off. It has workplace conduct, dress code, technology and communication, confidentiality, health and safety, performance and discipline, separation of employment, and it includes that all important acknowledgement. But if you actually read through these policies, they are much more sparse than what you are probably used to seeing. And then I refined the question a little bit. I went through and I said, I need a company handbook for a 30-person company that operates in Indiana and Illinois and has remote workers across the US. Immediately, you can see that this has beefed up and is much more detailed in some of its policies than the one was before. So I'll flip back quickly just so you can see the difference. But here it explicitly has an Illinois paid leave section, which is good. That is something that's required under Illinois law to have a policy on. So having this, by giving it a little bit better prompt, a little bit more tailored to my business, can have that additional information in there that specifically addresses areas where I actually operate, or my business actually operates, or your business actually operates. So having a little bit better prompt helps. But as you can see, there's still a lot of information to be desired. For instance, let's look at number 10, workplace conduct. Employees must act professionally. Prohibited conduct includes harassment, violence, and fraud. Hopefully there are more things prohibited. That's an interesting list that it picked out, like why it included harassment, violence, and fraud, but not potentially other crimes. But the language in here might give you good headers or good ideas and starting places of things to include in your handbook, but really it's not tailored at all to your company specifically. So I took it down a little bit of a different path. I asked it to create an employee handbook for me based on what Copilot knows about this company. And I gave it my law firm's website. So it just got kriegdevault.com. I then took that handbook that it generated for me based on what it knew about our law firm from publicly available information, and gave it the following prompt. Take this company handbook that Copilot had just generated and suggest edits in compliance with Illinois, Indiana, and federal law. What's funny is that Copilot explicitly found problems with what it generated for me. So without me changing a single thing, Copilot said, you need to have, there are practical gaps, here are some strengths, but it's high level for compliance purposes. It's missing important laws, specifically for Illinois, multi-state and remote workforce considerations, and federal compliance. Well, it's telling me all the things I missed when I asked it to make it for me based on this information. So you can see even from this that it is not great at generating. Let's look at some of the other areas that it found to be problematic. So it said there were critical missing pieces that needed to be added immediately. An at-will employment statement, a wage and hour and overtime policy, Illinois paid leave, FMLA leave, anti-retaliation policies, a complaint and reporting procedure, multi-state employment clarification. It also says that there's additional Illinois specific information that needed to be added. The confidentiality section needed to be expanded. The technology and remote work policy needs expanded significantly. And it said that there were biggest legal exposure areas on wage and hour claims, on Illinois compliance violations, on harassment, on misclassification risks, on at-will language. And it tells me all the ways to improve it. So it's funny that it had been what generated this handbook and then was very critical about its output. So you need to be twice as skeptical of AI's work as AI is of its own work. Now, it's not to say don't use AI. I think it can be very helpful to put in your existing company documents and ask for a high level, hey, what am I missing? Have there been any updates in the law since this? But as you're going through that, remember if you have just a general chat GPT or not enterprise license for any of these AI systems, that information is not confidential, and you need to be very, very careful that you are not uploading your company's confidential information into public software. So you need to make sure you're using it in a closed environment or an enterprise version of any of the software. You don't want to run afoul of company policies by trying to strengthen your company policies. So always be mindful when you're doing that. But as you can see, AI is not perfect at all, but it can be a helpful starting point. It actually did a great job of being critical in the handbook of where it missed on its own problems. So if you are needing extra eyes or a way to update this in the most cost effective way, I implore you to, if someone says, well, just pull one from ChatGPT, just pull something from the internet. I implore you to, for a business sense, tell the finance people, tell whoever's asking you to do that it would really be better to spend $1,000 up front and have legal compliance review it and make sure it actually fits what you do and how you do it and that it's compliant with the law than have violations. Because incorrect wording in your handbook can cost you more than that on just one employee, and then multiply that by your workforce. Spending the money and the investment up front to make sure it is done right can be the best business decision you have to mitigate risk and costs later. And having these policies and procedures in place can really fill gaps to prevent claims or disparate treatment. So, to mitigate the risk, as I mentioned, ensure your policies match your practices, review your policies at least annually if new laws are enacted which impact your workforce, review your entire handbook at least every 3 years to ensure it's up to date, practice what you preach, enforce your policies the same, keep copies of the acknowledgments, and document everything. And I briefly talked about this, why documentation is important. It can show why actions were taken or not taken with respect to an employee and mitigates claims of unequal treatment. It helps reduce legal costs down the line and provides a clean, verifiable way to show the company means what it says and follow through. Disorganized documents can lead to greater scrutiny for your company, which is not something anyone wants. Above all, employee handbooks should serve as clear, easy to understand guidance that promotes consistency in application of policies. A well-crafted handbook sets clear expectations and supports consistent application of these policies across the workforce while protecting the employer by documenting procedures and reinforcing compliance with applicable law. And I have seen some Q&A, so I will switch to that at the moment. That is at a high level everything I wanted to cover today, but I'm happy to take your questions and we'll switch to that chat now. I see there's a question of how does a handbook fit within a union shop employment contract? Can there be discipline outside of the union contract for violation of handbook policies? There can be a separate handbook. It is oftentimes in places that have a union shop, there are either two different handbooks. One is for union employees and one is for non-union employees. Another way to do it is to simply have an addendum that says this is specific to the union employees. I say that there could be something special about a union you're referencing. There could be something specific about a union contract that you're familiar with that prohibits that and it must not have document outside of the collective bargaining agreement. It's possible. But the instances I've been familiar with, we've had, for instance, municipal governments that have union employees and non-union employees. We have the CBA and we have the handbook, and there's essentially a document that within the handbook that says this controls all employees, to the extent that there is any conflict between the CBA and the handbook, the CBA controls because that's the contract. So there is a way to do that and have both coexist very well. Let's see here. For standard of conduct relevant to civility, is it advisable to use a reasonable person would find the behavior offensive language? That's fine. It's also one of those things that it depends on how your business operates, what you're talking about, what a reasonable person finds the behavior offensive, because there is so much today, especially in the world of social media and online content, that you just don't know what situation might pop up. You always should have language in there that allows the company to use its discretion in exercising any discipline and imposing any discipline. Let's see here. Someone else asks, do we really need to get a signed page by the employee acknowledging they received the employee handbook? Isn't it enough to show that the employee received the new handbook when they send it out in a blast email? You can show that, but then there might be an instance where the person says, well, it never got to me, or it went to spam, or I didn't see it. And this is a clear documented way to show their signature on that. And to be clear, I don't think that's necessary at the end every single time if you have an update to your policy or handbook. But at the onboarding for an employee, you know that you're always going to have an EEO statement. You always know you're going to have an anti-harassment statement. There are big policies and procedures that are not likely to change, that are going to be consistent, that are the ones that really will likely be challenged, that you want to show that they got it. It was their responsibility to read it and comply. I mean, especially with complaints, because you might have had, for instance, an employee who never once had made a single complaint at work, but then after they quit, filed a 10-page complaint with the EEOC alleging harassment. But if you have the documented policy that says, here's our method for reporting harassment, this person acknowledged that they received this policy and they never once followed it in the years of their employment and never complained about it, that really helps show and document that it wasn't known to the employer and that they just failed to act. By having that actual signed acknowledgement, the employee is responsible for knowing that. Let's see here. There's a question for what's the best practice of the actual acknowledgement. Make it be how your practice is, because some employers will say, here's your handbook, sign this document to acknowledge receipt. If you're going to do that, include in there an affirmative statement of, I have received this document. I understand it's my responsibility to read it. Because if you have someone who onboards and you hand them a piece of paper and a 50-page handbook, and they're immediately, as they sit at their desk, supposed to say, I have acknowledged, I have read and received. Well, they won't have read it at the time they signed it. So maybe if you're going to have them sign something saying they read it, make that be an obligation that a week after they get the handbook, then they turn in that paperwork, because you don't want the person to say, well, of course I didn't read it. They handed me that paper saying I read it and just had me sign off on it within 20 seconds of giving it to me. There's no real way of doing that. So avoid the challenge, make it consistent with how you actually do it. Let's see here. Another question. What kind of policy could you have that would help in a situation where a manager was told to keep a record of warning for an individual, then fired the employee, but did not actually keep any documentation? So in that instance, I think having policies that always say that everything is up to the discretion of their employer and they don't have to follow steps, but it's best practices to, that shows that there is an instance where the employer can use their discretion in how it should be done. Obviously, the manager should have recorded that things, and that might play into how a situation is resolved on the back end. But if the policy allows for multiple different ways to document, even if it's documenting after the fact, then you're acting consistently with the policy. We have another question here, and then we're going to wrap up, I think, Ryan, after this next one, unless we get another one come in. When you're located in multiple states, do you recommend addendums for each state or identify the state specific language in each policy? That's a good question. It depends how many states you operate in and how much variation there is. For instance, I've worked on instances where we have handbooks for employers that operate in California and Indiana. The policies vary widely. So when you have those multiple states, what I generally try to do, if it's 75 to 90% overlap in the policies, I have the general policies, and then within each policy, it will say to Indiana employees, to California employees, to Colorado employees, and break them down within that specific policy. And that helps you as the employer as well know that, okay, we have a harassment policy. Let's look at the harassment policy. Okay, in this state, this is how we operate. It also is a really quick way to pull and modify in case you choose to change locations where you do business. So I generally do have just state specific language within each policy, unless there is a reason for an addendum for each state. Sometimes there are. Sometimes if you're in 50 states, it's easier to give one Indiana packet and one Colorado packet, one California, one New York, one Florida, one Texas, and have them all in one place. But that gives more cross-referencing and more work to you potentially on the HR side that might want to avoid. So whatever works for you is the right way to do it. Neither is wrong. Okay, and it looks like those are all of our questions. I thank you everyone for your questions and your commentary today. I hope this has helped provide you information about the importance of handbooks and policies and procedures, and that you'll know and feel comfortable how to navigate these issues going forward.
Awesome. Thank you so much, Jenna. Very informative, very timely information, some great takeaways for our audience. I'm not just saying that, they are in the chat. A couple of standouts for me. One, follow company policies, follow company policies, follow company policies. Very often, our owners all across the states receive calls from customers, from HR, from other business leaders, stating that they suspect one of their workers is under the influence of alcohol or some other substance. Right? And they ask, what should we do? And our response is usually pretty standard. Is the person in a safe place? Are you concerned they may be experiencing a medical emergency? Okay, yes, no. Okay, what does your policy state? I don't know. We don't have a policy, or we haven't updated it in 10 years. Again, takeaway, just to reiterate, and correct me if I'm wrong, Jenna, but policy documents are only as protective as they are accurate, consistently applied, consistently maintained. Leaders should not be just asking, does our handbook look good? They should also be asking whether it genuinely reflects the organization's mission, values, their vision, and then make updates accordingly.
Yep, that's exactly right.
Awesome. Well, we have just a little bit more time, and I'd love for you all, if you get a moment, to please go to the chat, let everybody know what they thought about today's webinar. Give Jenna your feedback. We take the good, the bad, and everything in between. Again, your feedback helps to shape these Thrive webinars. So let us know what we can do better, what you would like to see in the future, any specific topics, any specific speakers. We'd love to hear from you. The survey link will also pop up upon completion of today's Zoom webinar if you don't have a pop-up blocker installed. Okay, next, if you are a credentialed HR professional, and I know that many of you are, 83% of our registrants for this webinar are HR professionals, mostly managers, directors, C-suite level. So please look in the chat for your activity IDs. These will also be listed on your certificate of attendance, which will be emailed to all participants by end of day next Tuesday, provided the entire webinar was attended. Next, as we talked about earlier, our registration for July's Thrive webinar with addiction medicine physician and MRO, Dr. Melissa Snyder-Adler, is now open. If you want to learn more about medical cannabis, aka medical marijuana, she doesn't like that, which she's going to tell you about, CBD, hemp, the differences, how you should approach disclosures of all those things in a risk-informed and safety-sensitive manner, register. You can do so right now for free by clicking on the link that is forthcoming in the chat. And finally, as always, if you have questions follow-up questions about today's topic and others, you're encouraged to reach out directly to your local ArcPoint Labs provider, especially if you have questions about our suite of employer solutions, such as drug and alcohol policy review and development, drug testing, both DOT and non-DOT, supervisory training, background screening, and our full service employee assistance program called Wellbeing Solutions. Check out at www.arcpointlabs.com/employer-solutions to learn more about those solutions and many others, or simply click on the link for that webpage, which is now in the chat. Thank you, ArcPoint Marketing. All right, we've reached the top of the hour, nearly. It's officially time for Thrive Words of Wisdom. Final takeaways. Jenna, what do you got?
Yeah, well, like I said, everyone, thanks for being here. Ryan summed it up very well earlier that the best way to have these policies and handbook work for you are to make sure that they are actually what you do. So as long as you have those in place, they will be a great foundation. Follow them, reference them, use them as a living document, not just something that lives in a file cabinet in the corner. So if you have any questions, feel free to reach out. I'm happy to help. If I or someone in my firm is not licensed in your office, we will be glad to point you to someone in your jurisdiction who can help. So it is always worth that question. 5 minutes on the phone can save a lot of headache and a lot of time down the line. So I appreciate all the feedback and all of the attendance today. Thanks, everyone.
Awesome. Thank you so much, Jenna. On behalf of the entire ArcPoint team, a very special thank you once again to today's Thrive presenter, attorney Jenna Shives with Creek DeVault, and to everyone attending, our valued partners and loyal members of the ArcPoint network. It is an honor to serve you and to help you create compliant, safe, and healthy workplaces that thrive. See you next month.